Hey, good afternoon, everyone. It looks like it's right at 12 o'clock, so I'm going to go ahead and get started. My name is Josh Peterson, and I'm an attorney here at Oliva Gibbs. I'd like to first thank you all for joining me today. By way of quick introduction and background, I grew up in the New Braunfels, Texas area, and my wife and I currently live in the Houston area. Our pride and joy is our son Reed, who's almost 2.5 years old. I also have an identical twin brother. So if you happen to see me, there's a 50% chance it's actually me. If it's not to worry, he can probably still answer most of your questions. Today's educational series is on the mechanics of washout provisions, and I'm going to be focusing mostly on Texas case law. I chose this topic because it consistently comes up in our practice, especially as it relates to title examination. It's my hope that this presentation will give you a good background on washout provisions and also hopefully give you some guidance on how to avoid unintended consequences in future transactions. We should have a few minutes at the end for Q&A. So if any questions come to mind during this presentation, feel free to type them and send them, and hopefully we can get to them at the end. I've divided today's topic into 3 parts to make it a bit more manageable. First, I'm going to start with some background and definitions as to what are non-operating interests. Second, what is a lease washout transaction? And importantly, third, what is an anti-washout clause? The most common non-operating interests are overriding royalty interests, net profit interests, production payments, and carried interests. These are all non-possessory interests. The owner of each of these has absolutely no right to operate the property, and they have no ability to go onto the property and drill or otherwise take action to perpetuate the lease. As most of us know, the override is by far the most common, and it's a cost-free share in the oil and gas produced that's carved out of the working interest. All of these interests depend on the continued validity of the oil and gas lease. So it's really important to remember that whenever the lease terminates, typically these types of non-operating interests are extinguished. What is an oil and gas lease washout transaction? Here's a short definition. It's a method that the operator uses to eliminate non-operating interests. And they do this either by releasing the lease or sometimes by simply allowing a current oil and gas lease to expire under its own terms. Why would an operator want to do that? Well, I'm sorry to say, but often it makes financial sense. Keep in mind, the end game for the operator is to extinguish these lease burdens. And by doing so, they're able to increase profitability and start with a clean slate. Normally, we see these washout transactions involving overrides, but it can happen to other interests too, including non-operating working interests, which we'll talk a little bit more about later. You might be thinking, is the operator even allowed to do something like this? Generally speaking, yes. Washout transactions are perfectly legal in Texas, with Texas courts taking a very permissible stance. The operator's intent is also irrelevant. So the operator can expressly say that the purpose of the washout transaction is to extinguish or get rid of these third-party interests and that's completely acceptable. So if we state that another way, an allegation that the operator is somehow acting in bad faith will almost never work. The primary reason that Texas courts seem to allow washout transactions is that they have repeatedly held that there's no special or fiduciary duty between the parties, even when the instrument contains an anti-washout clause. Thus, the Texas courts seem to be focusing on whether the termination was contractually permitted. Once the non-operating interest has been washed out or extinguished, the operator will then turn around and take a new lease on the exact same minerals, except this time it's free and clear of those interests that it extinguished. A majority of other states, just to name a few, Colorado, Louisiana, and North Dakota, seem to follow the Texas approach and have declined to impose a special or fiduciary duty unless there's, specific language to the contrary. There are a few minority states, including Oklahoma and Pennsylvania, that have held differently. Anti-washout clauses, we're going to see them most commonly in assignments or reservations of overriding royalty interests. Partial assignments of working interests generally do not contain anti-washout clauses. Since the override is carved out of the lessee's working interest, the override often cannot survive termination of the lease unless the instrument provides otherwise. So this leaves the override owner really particularly vulnerable to washout transactions, but there's a solution. The solution is to make sure the instrument that creates the interest includes an anti-washout clause, which is also known as a savings clause. Texas courts have even gone so far as to say it's the override owner's responsibility to include language that would save their interest from being extinguished. Here's a common example that you might see. Said interest is to apply to all amendments, extensions, renewals, or new leases taken on all or a part of the lease premises within 1 year after termination. And so that's kind of a standard anti-washout clause that you might see. The next question we have to ask is whether a lessee under a new lease is bound by the anti-washout clause. The answer is yes, if certain conditions are met. The first condition is there has to be privity. Now, if we go back to some of the fundamentals, we'll remember that an oil and gas lease is both a conveyance and a under basic contract law, there has to be contractual privity in order for there to be any kind of contractual obligation to the other party. What that means is that the lessee under a new lease will typically not be bound by the anti-washout clause unless that lessee or possibly an affiliate owned an interest in the lease. So let's take a look at an example here that's up on the slide. We have oil company A who takes a lease and then assigns it to oil company B. In that assignment, oil company A reserves a 2.5% override. And they include an anti-washout provision that applies to renewals, extensions, and new leases taken within 1 year after termination of the original lease. So the lease expires, and then 6 months later, C comes along and takes a new lease. Is oil company C's new lease burdened by A's override? The answer is no, because there's no privity of contract between oil company A and C. The only exception here might be if oil company C happened to be an affiliate of oil company B. Here's one more example relating to privity of contract. Similar facts as the other slide. A assigns the lease to B, and A reserves an override, which includes an anti-washout clause. The difference here is B assigns a 10% working interest to C. The lease then expires, and 6 months later, C comes along and takes the new lease. Is oil company C's new lease burdened by A's override? The answer here is yes, because C owned an interest in the original lease. And so there's privity of contract between oil company A and C. The result is that A's anti-washout clause is effective as to C's new lease. So in summary, C's lease is going to be burdened by A's override. And I know this actually comes up a lot during our title examination as far as to, overrides reserved by certain parties, and it becomes a question of whether the client's new lease is in fact burdened by prior overrides and anti-washout clauses. So the privity is definitely very important. Okay, so next, the situation really needs to fall squarely within the anti-washout clause. So it's important to remember that Texas courts construe these anti-washout clauses really narrowly. And one of the first cases involving an anti-washout provision, and the one that you'll see cited most frequently, is the Texas Supreme Court's 1967 decision in Sunak v. Parks. In the Sunak case, Parks sold and assigned to a third party a mineral lease that was later transferred to Sunak. Parks reserved an overriding royalty interest which included an anti-washout clause. Specifically, the clause stated that the override will apply to production from the current lease in any extension or renewal. It's important to note that the anti-washout clause in this case did not specifically state that it applied to new leases. The assignment also included a surrender clause, and that gave Sunak the right to surrender any part of the lease without the consent of Parks. Later, the lessor ended up questioning whether the lease was properly pooled with an adjacent tract. So what happened was Sunak obtained a new lease on the same land, but with different terms. And so Sunak stopped paying the overriding royalty owed to Parks under the original lease. The Texas Supreme Court held that the original lease had terminated and that the new lease was not a renewal and extension. The court said that a lease extension generally means the prolongation or continuation of the term of the existing lease. We also see sometimes it can include enlarging the acreage or the depths to be covered by the lease. But that was not the case here. In Sunak, we had a new lease, same land, and the terms were substantially different. The court also didn't regard the new lease as a renewal. since the new lease was entered into well over a year after the old lease had expired. Again, it was under different terms and for new consideration. So the result in Sunak was that the override was washed out. It was not saved by the anti-washout clause because the facts didn't fit squarely into the extension or renewal clause. So the takeaway here is if you have an anti-washout clause that only applies to extensions or renewals, that is pretty limiting because, again, a new lease oftentimes is not going to fall into that category. The court in Sunak held that an assignment of an oil and gas lease that reserves the override does not create any confidential or fiduciary relationship between the parties. And that's kind of the original holding that you'll see throughout a lot of these cases. Just because there's an assignment or reservation of an override, that by itself does not create any special duty or relationship to the parties. Additionally, the court did cite the surrender clause in the assignment in finding that the parties, again, had no special relationship to one another. Okay, so remember that the lessee operator in the Sunak case did have the added benefit of a surrender clause. As a refresher, the surrender clause grants the lessee the right at any time to surrender the lease, and they can do that in whole or in part to the lessor and then be relieved of all obligations under the lease. But what happens if there is no surrender clause? The 14th Court of Appeals out of Houston answered that question back in 1992 in Exploration v. Vega. The Vega case was very similar to Sunak. It involved an override that was washed out. Same as Sunak, there was an anti-washout clause that was limited to extensions and renewals. But here in the Vega case, there was no surrender clause giving the operator the absolute right to surrender the lease. The override owner tried to argue that the renewal and extension language did create a fiduciary duty unless there is a surrender clause to negate it. The Court of Appeals held that there was still no fiduciary duty between the parties, despite the lack of a surrender clause. The court went on to discuss some of the situations where there is a fiduciary relationship. So that would be attorney-client, partners, close family relationships. The court did say that a fiduciary duty can also arise if over a long period of time the parties have worked together, maybe they've done some joint acquisitions and development together, and all that happens before the assignment or reservation. But in Vega, the court found no evidence of that, so the override was washed out. And I think basically what the court is doing there is they kind of left open a small window to say there may be some very unique facts where the parties have a relationship, they've worked together, they've developed the property, and then we have an assignment or a reservation of an override. There may be some very specific facts that could create a fiduciary party, but that was not present in Vega. And it seems like it would take a very special set of facts for the court to reach that conclusion. So what if the override owner wants to try to protect its interest by creating a fiduciary duty with its working interest owner? Well, they could include specific language to that effect, and here's an example of language they could attempt to negotiate. Lessee owes overriding owner a fiduciary duty to deal with the leased property in a manner that will protect the override owner's interest against any action or inaction by the lessee. That might be wishful thinking for the override owner because, of course, the operating lessee is going to really push back on that language because if you read that, not only could the operator not intentionally surrender the lease, it could even be implied as, implying a duty to develop. So that clause is very favorable to an override owner if they could, get it into the instrument, not so much the operator who's going to likely push back. Here's another example of where the situation really does need to fit squarely within the anti-washout clause. In 2018, the Texas Supreme Court issued its opinion in TRX v. Anadarko. Instead of an override, this case involved a 5% back-end percentage of the working interest, but the exact same principles that we've already discussed would still apply. Under the original lease, Anadarko was required to drill an offset well, and when that didn't happen, that triggered a clause requiring a release. The landowner then demanded that Anadarko execute a release. Anadarko took a look and said, yes, we have breached the offset requirement, and therefore the original lease had terminated. Anadarko then worked with the landowners and they signed a new lease, this time with materially different terms. Additionally, the new lease neither mentioned the original lease nor did it include any language releasing it. Subsequently, Anadarko executed a release of the original lease. So TRO then approaches Anadarko to confirm that its back-end interest in the new lease was valid under their anti-washout clause. Anadarko denied that it was. Now, TRO did have the added benefit of an anti-washout clause, and it stated that it would apply to and extend to any renewals, extensions, or top leases taken within 1 year of termination of the underlying interest. However, the anti-washout provision here did not mention anything about new leases. So the argument became, was the second lease a top lease or just a plain new lease? In its analysis, the Texas Supreme Court explained that basically a top lease is a subsequent oil and gas lease which covers a mineral interest that's already subject to a valid prior lease. The court clarified that when a lessor and a lessee under an existing lease execute a new lease, the existing lease is terminated unless the new lease states otherwise. For example, if there's language in the new lease making it subject to or subordinate to the prior lease. Here, Anadarko's new lease said nothing about being subordinate to the original lease. Therefore, Anadarko's new lease effectively terminated the original lease, even though it took some time later before there was a formal release. So the conclusion of this case is that the new lease was not a top lease. And so the back-end interest was washed out. And if you're thinking, could all this have been avoided if the anti-washout clause had applied to new leases? The answer is yes. But unfortunately, the anti-washout clause mentioned nothing about new leases. So far from a non-operating interest owner's perspective, we've seen that the anti-washout clause should be drafted broadly so it covers a multitude of situations. We know it shouldn't just be limited to renewals and extensions. It needs to also cover new leases. And that was what we just learned in the TRO case. Um, as many of us typically see, the new lease language is common within anti-washout clauses, and it's often limited to new leases taken within 6 months or a year of the original lease terminating. But we have to consider the rule against perpetuities, and that's something that we need to take into account when drafting our anti-washout provisions. The anti-washout clause must not violate the rule against perpetuities. It's also known as the rule, which I'll refer to it. It's inherited from the English common law, and it's notoriously difficult to both understand and apply. I think a lot of us learn, and for the attorneys out there, there's a famous Supreme Court case in California back in 1961 that even held it was not legal malpractice for an attorney to draft a will that violated the rule against perpetuities. But nonetheless, it's something we need to dive into here. The prohibition against perpetuities, for one, it's found in the English common law, but it's also in the Texas Constitution. In the Texas Constitution, it states, perpetuities and monopolies are contrary to the genius of a free government and shall never be allowed, which is pretty strong language. The common law definition is one I'm sure most of us have probably seen at some point. And here's an example of what you might see sometimes. No property interest is valid unless it must vest, if at all, within 21 years after the death of some life or lives in being at the time of the conveyance. As a quick side note, as it relates to trusts, last year the Texas legislature did pass a law simplifying the rule to 300 years for a vesting period, but unfortunately for us in the oil and gas industry, that change was only applicable to trusts. And even for trusts before 2021, the old rule still remains in force. And so if a grant or devise could violate the rule at the time of the conveyance is signed, the interest is void. Now, the goal of the rule is to prevent unreasonable restraint of alienation, which is generally the right of somebody who owns property to be able to buy or sell it as they see fit. The rule it's kind of a game of proof, with the goal being to prove that the interest will vest or fail to vest during some person's life or within 21 years after that person's death. One question that people always seem to ask is, where did the number 21 come from? Well, originally in English common law, the rule applied only during a person's life, but then it was later extended an additional 21 years to allow members and children to reach the age of majority. Okay, so I think the rule is better understood through an example. So let's take a look at a very recent Texas Supreme Court case in 2020 where the rule was applied to an override and an anti-washout clause. And the case is Yao versus Granite Operating. And I'll go through the facts quickly here, but it's also up on the slide, just a short kind of explanation of what took place. So there was a series of conveyances, and the Yaos ended up acquiring an override interest in a 1986 lease, with Granite owning the leasehold interest. Now, the override did have the benefit of an anti-washout clause that purported to cover any extension, renewal, or new lease. There was then a dispute whether the 1986 lease had terminated due to lack of production. So Granite and the mineral owner ended up executing a top lease in 2007. And the original 1986 lease was then released. So, as you might have guessed, Granite decided to stop paying the Yao's override, claiming the override from the 1986 lease did not burden the 2007 lease. So Granite is basically arguing that the Yao's override and the anti-washout clause violated the rule against perpetuities. The court, in its opinion, went on to reiterate that if a grant could violate the rule at the time it was created, then the interest is void. So that's kind of, for Texas, we look at, when we're looking at the rule against perpetuities, we're really looking at, does it violate the rule at the time it was created? The rule does not apply to present property interests or to future interests that vest at the time of their creation. So the Supreme Court, in its analysis, the first question they asked was, did the Yao's override in the new 2007 lease vest at the time it was created? Remember, if the interest vests at the time it's created, then the rule doesn't apply. If an interest can only vest upon the happening of a condition or an event, then it's an executory future interest that's subject to the rule. Here, the Yao's override in new leases did not vest at the time of the 1986 lease because there was no immediate fixed right to leases not in existence yet. So if we put that simply, we could say that the override cannot already be vested in something that doesn't exist yet, and it may never exist. So as to the first question, did the interest vest at the time it was created? The answer is no. The second question the Texas Supreme Court asked was, must the interest vest, if at all, within 21 years after the death of some lives and being at the time of the reservation? The court also answered this question no. And they did so because the Yao's override in new leases was really contingent on 3 events happening, which may never occur within the rule's time frame. First, for the Yao's interest in a new lease to vest, the original 1986 lease has to terminate. Second, the mineral owner then has to actually sign a new lease, an event which may never happen. And third, for the interest in the new lease to vest, the lease must be obtained by Granite or a successor of Granite. And that's essentially the privity requirement. That event may never occur either, or it could occur long after the new lease is signed. So in conclusion, the Yao's override interest in new leases violated the rule against perpetuities. Importantly, the Texas Supreme Court did make a note that they agreed with a 10th Circuit Court case in finding that renewals and extensions are vested at the time of creation and therefore not subject to the rule. So just as a quick recap, the renewal and extension language in an anti-washout clause is considered vested and not subject to the rule. So you see the renewal and extension language, it's vested, you don't have to worry about the rule against perpetuities. However, when you come across the new lease language in an anti-washout clause, that's completely different because it is subject to the rule against perpetuities. Okay, so the Yow's override in new leases violates the rule and would be considered void. However, that's not the end of the story, because under the Texas cypre statute, courts are required to reform property interests that violate the rule. And up on the slide, you'll see the actual statute. And specifically, the statute requires courts to reform or construe an interest in real property so that it fits within the intent of the creator and fits within the rule against perpetuities. So essentially, it's a mandate to courts to try to massage the language and revise it so that it will fit within the rule. The Texas cypre doctrine, it's originally a principle of law that was used to save charitable trusts, but it's been expanded since then. In the Yow case, the operator first tried to argue that to qualify for reformation under the statute, the instrument must be a trust or a will, which, to be fair, is usually where we see the cypre doctrine coming up. But the court rejected that argument because, as you'll see, the statute is written very broadly and it's intended to apply to legal and equitable interests. And so it's not limited to only trusts and wills. The next argument the operator tried to make was that a corporation could not make an inter vivos instrument. The court dismissed that for several reasons, including the treatment of corporations as persons for the creation of trusts. So, in other words, because a corporation can make an inter vivos conveyance of property to create a trust, the court just applied the same reasoning that a corporation can make an inter vivos instrument that qualifies for reformation under the statute. And that's a really important holding because the court is saying that the Texas Reformation statute applies to corporate conveyances and transactions. Okay, so we know that the Yow's override in new leases violates the rule against perpetuities, but we have a silver lining. And that silver lining is that it's eligible for reformation under the Texas statute. What happens next? Well, the Texas Supreme Court remanded the case to reform the interest if possible, which of course just creates more litigation costs for the parties. And there's still uncertainty how the lower court might reform the interest to fit within the rule. So because a non-operating interest that violates the rule is eligible for reformation, I think it's likely that many disputes on this subject are going to be settled outside of court because, again, it may violate the rule against perpetuities, but it's subject to reformation, and how a court might reform that is it's uncertain. There's one last takeaway from the Yao case that I think is worth mentioning. The court held that the Texas Reformation statute is not subject to the 4-year statute of limitations. And the reason for that is this statute is a remedial mandate to the courts on how to remedy a violation of the rule. And so this statute, it's not a cause of action or a lawsuit that's subject to a statute of limitations. So again, when reforming interests under the Cypre statute, there is no applicable 4-year statute of limitations. Okay, so on this slide, I've just got a few key points to remember. From a high level, if you're the owner of a non-operating interest, please make sure to draft your anti-washout clauses broadly. Here's an example. You could include something along the lines of this. This reservation or interest shall apply to amendments, modifications, replacements, renewals, extensions, or new leases that the assignee or his successor or assigns may secure. And again, a lot of times you'll see that it's limited to 6 months or a year after termination of the original lease, and that's just up to the parties to negotiate. The second thing to remember is to add rule against perpetuity savings language to the anti-washout clause. There's 2 different ways to do this. One way would be to use just a firm period of 21 years from the date of the document. Although that's the simplest method, it would not protect the non-operating interest. For example, if a lease is held by production for more than 21 years, because again, under the first method, it's simply a hard cutoff of 21 years from the creation of the interest. The more common and protective approach for the non-operating interest owner is to limit the washout interest to 21 years within some lives and being at the time of the conveyance. Here is a sample savings clause that could possibly be used. Any interest granted or reserved under this instrument, which would violate the rule against perpetuities, shall terminate no later than 21 years after the death of the last survivor of, and then that's where you could list the named person or persons alive on the effective date of the instrument. That would affect whether the interest vests. Of course, you'll want to tailor your savings clause to your specific transaction. It's up to the negotiating parties, which names are listed and how many names are included as the measuring lives. It can just be one name, or you could state that the measuring lives are all the signatories to the conveyance. The measuring lives also don't have to necessarily be involved in the transaction. So you could hypothetically list the Duke of Edinburgh and his children and grandchildren who are living at the time of the instrument. The point is, the measuring lives do need to be specific and they do need to be ascertainable. And obviously, if you're the owner of the override, the more names you include, the longer that anti-washout clause would be applicable. Okay, I've spoken about washout transactions mostly in the context of overrides, but let's switch gears a little bit and talk about working interests. When it comes to washout transactions, there are a lot of similarities between overrides and non-operating working interests, but there's also some very important distinctions. So let's just start with a quick overview of working interests. A working interest is the interest owned by the lessee of an oil and gas lease. It's called a working interest because it grants the lessee the right to work on the lease property and to search for, develop, and produce oil and gas on the property. So unlike an override interest, the working interest owner has a possessory interest, right? So the working interest owner has a lot more control whether a lease is perpetuated beyond its primary term, because it does have the actual right to go on the property, conduct operations, and produce oil and gas. As we've seen, absent a savings clause, an override owner is really basically at the mercy of the operator to develop the original lease, and they have very little recourse if the operator decides to release the lease or allow it to lapse. However, if we have multiple working interest owners and one of them releases its interest, it does not release their co-tenant's working interest. Because of these differences, we usually do not see anti-washout provisions in partial assignments of working interests. Okay, so I'm going to talk about two cases involving washouts of working interests. The first is an example from the Texas Supreme Court in 2004, where a working interest owner intentionally washed out one of their co-tenants' working interest. The case is Ridge Oil versus Gwin Investments. At issue here was a single oil and gas lease from 1937, and it covered 2 tracts of land. Ridge owned the leasehold in one tract, while Gwin owned the other. At one time, there was a producing well on the Gwin tract, but it was plugged and abandoned back in 1950. There was production from 2 wells on the Ridge tract from 1937 all the way up until 1997. And those 2 wells held the lease as to both tracts until 1997. In 1997, Ridge, he approached Gwin and offered to purchase Gwin's tract, which was rejected. This led Ridge to attempt a washout transaction. As mentioned before, the working interest owner does not have the authority to release a co-tenant's working interest. So what Ridge did here was he cut off the electricity to the 2 wells, and so he intentionally and voluntarily ceased production on the Ridge tract for 90 days. And he did this in order to allow the lease to expire according to its own terms. Ridge had communicated this plan to the lessor and explained how he intended to release both the tracts. Ridge ended up going through with this plan, and he released the entire property, both tracts, in 1998. The issue before the court was whether the 1937 lease remained in effect as to the Gwin tract. Now, as most of us know, the general rule is that production from any one tract will usually continue the entire lease as to all the tracts. Gwin argued that the 1937 lease was continued in effect through the temporary cessation doctrine. On the other hand, Ridge contended that the 1937 lease terminated either when production ceased or when he had executed those new leases with the mineral owner. The Texas Supreme Court focused on Ridge's second theory and found that on the date the new lease became effective for the Ridge tract, there was a cessation of production with respect to the 1937 lease. The court noted that it's well established that a lease can terminate by surrender, mutual agreement, or by signing a new lease. In other words, when Ridge took the new lease, he effectively surrendered his tract under the old 1937 lease. Here, Ridge had no right to release the Gwynn tract. However, because all the production after 1998 was under the new lease, the 1937 lease terminated due to non-production. Gwynn tried to argue that Ridge could not wash out his interest in this manner, and like a lot of the cases we've seen, the Texas Supreme Court disagreed, and they took a look at the cases involving overrides, and they applied a lot of the same reasoning in allowing this washout transaction. Ridge had no rights or duties with regard to any other tracts other than the Ridge tract. Likewise, Ridge owed no duty to Gwynn to continue the 1937 lease. The mineral owners of the Ridge tract and the working interest owners of the Ridge tract were completely free to, agree to sign a new lease, which terminated the 1937 lease. Now, the result of this may seem slightly unfair, but I think it's important to remember that Gwynn, the well on his land, it was P&A'd back in 1950. So he had every opportunity from 1950 to 1998 to drill a well, but simply chose not to. Okay, the last case I'm going to talk about is it's Cimarex v. Anadarko. And this is a case out of the Texas Court of Appeals, 8th District. And here's a flow chart up on the screen for you. I think in the ideal world, an oil and gas lease would cover the entire mineral interest. But as we know, that's often not the case, and a lease will often cover less than 100%, with the remainder being leased by a third party. Now, normally, the various lessees who are co-tenants will enter into a joint operating agreement and will be given the opportunity to participate or invest in the drilling of a well. But what happens when one lessee decides to drill a well and refuses to allow another lessee a chance to participate? Will the non-participating lessee's lease be deemed to be held by production? And that's exactly what happened here. In this case, Cimarex obtained a lease covering a 1/6 interest in the 440-acre tract. The primary term of the Cimarex lease was for 5 years, and the habendum clause stated that the lease would remain in effect for a secondary term as long thereafter as oil or gas is produced from said land or from land with which said land is pooled. The other 5/6 mineral interest eventually became owned by Anadarko. Anadarko drilled 2 wells, one in 2011, one in 2012. From the very beginning, Cimarex offered to join in the participation of the wells, and they offered to pay their share of costs and expenses. Anadarko declined the requests and then took top leases for from Cimarex's lessors. I think we can probably see where the facts of this case are headed. By declining to allow Cimarex to participate in the wells, Anadarko is attempting to wash out their lease by allowing it to expire under its own terms. Even after the well is paid out, Anadarko refused to pay Cimarex anything. There was a settlement agreement, but that was really only a temporary fix. The primary term of the Cimarex lease expired in 2014, and then Anadarko proceeded to pay the bonuses on the top leases it had taken. Anadarko contended that after the primary term of Cimarex's lease had expired, Cimarex no longer owned an interest in the well. So the main question before the court was, can Cimarex's lease be perpetuated by the drilling of a well by Anadarko? The answer to that question really depends on how you interpret the addendum clause, which is also known as the secondary term. You'll notice that the addendum clause in the Cimarex lease, which is at the bottom of the slide, does not state that the oil and gas lease has to be produced by the lessee. Nonetheless, the Court of Appeals relied on its prior holding in Hughes and held that the Cimarex lease had terminated because the lessee, being Cimarex, did not cause the production itself. So there's definitely a number of critics of that decision. Looks like we've only got a few more minutes of time, so I'm going to kind of skip through a little bit of the analysis from that case. But the summary from that case is that, the El Paso court is saying that a non-participating lessee, can't ride the coattails of a producing co-tenant. Now, how could the results have been different? Well, it's important to note that the secondary term said nothing about who must produce the oil and gas lease. So if Cimarex could have a redo here, then they really should have provided that any production from the lease would extend it into the secondary term, regardless of whether the lessee itself participated in or conducted operations. And if that language had been included, then Anadarko's production would have continued Cimarex's lease. So in conclusion, I think it's important to review all of your existing non-operating interests and just take a look and see if they're at any risk for being washed out. If there are at risk, you could try to propose an amendment. Second thing, take a look at your interests and make sure there's not any rule against perpetuities issues that may come up. For a lot of these things, it's much easier to address these issues on the front end versus looking back and trying to fix it, which may not even be possible. It looks like we've run short on time, so if anybody has any questions, please feel free to reach out to me directly. My contact information is on the first slide, and I just really appreciate everybody joining our educational series. And again, if you have any questions, feel free to reach out to me. Again, thank you all for attending, and I hope everybody has a great day.